Let me be clear right from the start. What you say during a breathalyzer test can make the difference between walking away free or being charged with a DUI that could haunt you for years. I've seen smart, responsible people destroy their own defense in less than 30 seconds, not because they were drunk, but because they didn't understand how the law and their body intersect in those critical moments. When those flashing blue and red lights hit your rearview mirror, your heart starts racing. You pull over. The officer approaches. You know what's coming, the breathalyzer, and suddenly every word that comes out of your mouth is evidence. You may think you're just being polite, cooperative, or honest, but in reality, you're building the prosecution's case against yourself. Here's what most people don't realize. From the moment you're stopped, the officer isn't just observing your driving. They're recording your tone, your coordination, your word choice, your breath pattern, even the dilation of your pupils. Every breath you take and every phrase you say becomes a data point, a behavioral clue that the prosecution can use to justify a DUI arrest or increase penalties later. So today, I'm going to walk you through the exact phrases you should never say during a breathalyzer test, and more importantly, why they're so dangerous. Because the key to surviving that moment isn't about tricking the system, it's about understanding how the system works. Let's start with one of the most used lines. 1. I only had a couple of drinks. This is the single most common, most damaging statement people make. It feels innocent, even strategic. You're trying to sound honest, cooperative, even modest, but in legal terms, you've just admitted to consuming alcohol. That statement, in itself, establishes probable cause. Once you admit to any drinking, the officer no longer needs to rely solely on their observations. They now have a verbal confession tied to your physiological state, your speech, your eyes, your coordination. From a legal standpoint, you've just handed them the foundation for the DUI charge. And here's the scientific problem. Your couple of drinks doesn't mean much in biological reality. Alcohol absorption isn't linear. It depends on your body weight, liver enzyme efficiency, hydration level, stomach contents, and even hormonal fluctuations if you're female. 2 drinks can mean a blood alcohol concentration, BAC, anywhere between 0.22 and 0.10, depending on those factors. Even worse, alcohol doesn't distribute evenly through your body right away. It takes 30 to 90 minutes for ethanol to equilibrate between your bloodstream and your breath. So if you're pulled over shortly after drinking, your breathalyzer may overestimate your BAC, since alcohol in your lungs can spike faster than what's circulating in your veins. By admitting to drinking, you destroy your ability to argue that discrepancy later. So, instead of saying, I only had a couple of drinks, you say nothing about drinking. You're not required to. You can calmly say, Officer, I prefer not to answer any questions. That's it. It's polite, it's legal, and it protects your defense. 2. I'm fine to drive. This phrase sounds harmless. You're just trying to reassure the officer, but what you're really doing is offering a subjective medical assessment about your own condition. That statement can and will be used against you later. Here's why. When you say, I'm fine to drive, you've established a position that can later be proven false with data, either through the breathalyzer, a blood test, or video evidence. If your BAC later tests above the legal limit, the prosecution will argue that you were impaired and unaware of it, proving recklessness. That elevates your case from a standard DUI to aggravated negligence in some jurisdictions. And physiologically, that claim doesn't hold up. Alcohol affects your cerebellum, the part of your brain that manages balance and fine motor control, long before you feel drunk. It also suppresses your prefrontal cortex, responsible for judgment and decision-making. In simple terms, alcohol makes you less capable of evaluating your own level of impairment. So when you feel fine, your brain may already be misjudging your coordination by as much as 30–40%. Saying I'm fine to drive gives prosecutors a clear contradiction, your statement versus your later BAC result. They'll use that to argue you were overconfident, irresponsible, and therefore guilty. The correct move? Say nothing about your condition. You're not required to self-assess. Let's go deeper into how your body interacts with this process, because understanding that physiology gives you power. The breathalyzer doesn't actually measure alcohol in your blood. It measures ethanol vapor in your breath, which correlates imperfectly with your blood alcohol concentration. The standard ratio used in most US devices is 2100.1, meaning the device assumes that for every 1 molecule of alcohol in your breath, there are 2100 in your blood. But this ratio varies significantly between individuals. It can range from 1700.1 to 2400.1 based on temperature, metabolism, and even lung volume. That's why officers are trained to wait 15 minutes before administering the test, to make sure no residual mouth alcohol from recent drinks, burps, or mouthwash skews the results. But not every officer follows that waiting period precisely, and if you've been talking, hyperventilating, or even vomiting, drinking, your breath sample can easily spike higher than your true blood level. This is why it's so important not to say anything unnecessary during that waiting window. Every word increases your respiration rate and changes the composition of your breath sample. It sounds small, but I've seen cases turn on that single detail. 3. I know my rights. Listen carefully. Invoking your rights and announcing that you know your rights are two very different things. The first is legally sound. The second makes you look combative and often triggers a defensive posture from the officer. When you say, I know my rights, what the officer hears is, I'm going to challenge your authority. That can escalate the tone of the encounter and make them document your behavior as non-cooperative. Once that word appears in the police report, your credibility with a judge immediately drops. More importantly, breathalyzer tests are regulated by implied consent laws in every state. The moment you accept a driver's license, you've legally agreed to submit to certain forms of testing if an officer has reasonable suspicion of impairment. Saying, I know my rights won't stop that process. It just invites more scrutiny. Here's the strategic alternative. Calmly say, Officer, I would like to speak to an attorney before answering any questions. That's an invocation of your right, not a declaration. It signals intelligence and restraint, not hostility. 4. I refuse to take the test. This one's complicated because it sounds like the smart move. You've probably heard people say never blow, but that advice is dangerously oversimplified. Refusing the test doesn't make the problem go away. It triggers automatic administrative penalties in every state. Here's how it works. Under implied consent, refusal typically leads to an automatic license suspension, even if you're never convicted of a DUI. In some states, refusal adds criminal penalties that can exceed those of a first-time DUI. But there's also a physiological reason to think twice. Alcohol metabolizes in the liver at an average rate of 0.015 BAC per hour. So if you delay testing, your BAC may drop before a blood draw, weakening the prosecution's evidence. That's the argument people use to justify refusal. But courts are aware of that strategy, and they now often interpret refusal as consciousness of guilt. So instead of outright refusal, the smarter move is to remain calm and clarify, am I legally required to take this test? If the officer confirms you are, comply. That phrasing documents that you're following the law, not resisting it. It preserves your right to challenge the procedure later on the grounds of calibration, timing, or observation errors. Remember, the breathalyzer result is not the final truth. It's a number generated by a machine that assumes your biology matches a statistical average. The moment you understand that, you stop being intimidated and start making rational decisions. 5. I haven't had anything to drink. This one might sound like the logical opposite of I only had a couple, but it's just as dangerous, maybe even worse, because now you've made an absolute statement that can be scientifically tested and disproven. If your breathalyzer shows even a 0.01 BAC, 0.01 BAC, or if an officer detects alcohol odor or behavioral cues, your credibility evaporates. Prosecutors love that. They'll play that clip in court and say, ladies and gentlemen, the defendant lied to the officer. Once your honesty is questioned, the rest of your defense collapses. What most people don't realize is that alcohol metabolites, specifically ethyl glucuronide, ETG, can remain in your system for up to 80 hours after your last drink. Even trace amounts can appear on a breath or urine test if you used mouthwash, cough syrup, or certain foods cooked with wine. So saying, I haven't had anything to drink can be technically false without you even realizing it. The smarter move is to decline to answer. Remember, the Fifth Amendment protects you from self-incrimination, but it doesn't protect you from making false statements. Silence is legal. Lying is a crime. So when the officer asks, have you been drinking tonight? The best answer is, I prefer not to answer any questions. It's calm, it's non-confrontational, and it preserves every legal defense you may need later. 6. Can't we just skip the test? Never negotiate during a stop. You might think you're appealing to the officer's humanity, trying to reason your way out of trouble, but what you're really doing is confirming their suspicion that you have something to hide. Officers are trained to read negotiation as implicit admission. In fact, most DUI training manuals teach them to document attempts to delay or avoid testing as additional indicators of impairment. From a legal standpoint, that phrase damages you in two ways. First, it reinforces the officer's probable cause. Second, it gives the prosecution narrative control. They'll argue that you knew you were impaired. Otherwise, why would you ask to skip the test? Now let's step back and examine how your speech patterns play into all of this. Because you can say all the right words, but if you say them in the wrong way, your tone alone can convict you. Alcohol doesn't just affect your balance or coordination. It interferes with your vagus nerve and cranial nerves 9 and X, both of which control the muscles of your mouth, tongue, and throat. That's why even slight impairment causes slurred speech, delayed consonant articulation, and rhythmic irregularities in your voice. Officers don't need a lab to detect that. Their body cams record everything. When your speech slows, your sibilant sounds drag. S and T become thick, muffled. Those are neuromuscular cues of impairment. And even if your BAC is below the legal limit, that recording gives prosecutors visual and auditory evidence of intoxication. That's why I tell my clients, don't talk more than necessary. Keep your tone measured and your words precise. Every extra syllable is a chance to expose the chemistry in your bloodstream. 7. I wasn't speeding. This might sound unrelated to a breathalyzer, but it's critical. When you challenge the officer's reason for pulling you over, you're inviting a confrontation, and confrontation shifts their focus from investigation to control. Here's what happens next. Instead of evaluating your impairment, the officer starts testing your compliance. They'll prolong the stop, observe your emotional regulation, and document your defensive behavior. That creates a pattern of escalation they can later justify in court. And if your tone gets irritated or your gestures become sharp, even if you're completely sober, that stress reaction looks like intoxication on camera. Elevated heart, rate, flushed skin, erratic breathing. All of those are autonomic nervous system responses that mimic the physiological profile of alcohol impairment. The correct response is not to argue. It's to stay calm, acknowledge the stop, comply with instructions. Yes, officer. Here's my license and registration. I understand. Short, controlled, neutral. Every phrase reinforces that you're rational and respectful. That tone builds credibility, and credibility is what wins in front of a judge. 8. I can explain. This is perhaps the single most destructive instinct people have, to defend themselves verbally. The moment you say, I can explain, you've entered a psychological trap, because now you're in narrative mode and every detail you offer becomes evidence. Maybe you say, I was coming from a party, but I only had one drink. That's a confession. Maybe you say, I haven't eaten all day. That's why I feel lightheaded. That's an admission of physiological impairment. Or maybe you say, I'm just nervous because I've never been pulled over before. That tells the officer you're in a heightened emotional state, which makes your behavior easier to misinterpret. What you think is explanation, the officer interprets as justification, and justifications are rooted in guilt. Instead, remember this: you don't owe an explanation. Your job is not to prove your innocence at the roadside. Your job is to protect your record so your attorney can prove your innocence later. If the officer asks where you're coming from or going, you say, I'd prefer not to answer any questions. You're not being difficult, you're being disciplined. Now let's pause here to talk about how alcohol actually moves through your body, because once you understand the mechanics, you'll understand why every breath, every word, and every minute matters. When you drink, ethanol passes through the stomach and small intestine, entering your bloodstream through diffusion. From there, it travels to your liver, where alcohol dehydrogenase, ADH, breaks it down into acetaldehyde, a toxic compound later converted into acetic acid, and then carbon dioxide and water. This process is steady. Your liver metabolizes roughly 0.0 coffeine BAC per hour, regardless of how much you drank. But absorption happens much faster, within minutes if you drank on an empty stomach. That's why your blood alcohol can rise sharply after 1 or 2 drinks, even if you feel fine. Now, here's the critical part. Breathalyzer tests don't measure alcohol in your blood. They estimate it from the alcohol vapor in your alveolar air, deep in your lungs. But if you've just exhaled rapidly, laughed, or hyperventilated, your alveolar air ratio changes, meaning your test result can fluctuate by as much as 15 to 20%. That's also why officers are trained to observe you for 15 minutes before the test. Any burp, hiccup, or regurgitation can push mouth alcohol into the sample, giving a false high reading. And yet, if you talk too much, you can involuntarily trigger those same distortions. Talking releases carbon dioxide, cools your airway, and alters the diffusion rate of alcohol vapor. You could literally talk yourself into a higher reading. That's why I keep repeating calm, minimal speech. The less you talk, the more consistent your physiology stays, and the more defensible your result becomes later in court. 9. I don't need a lawyer. Never say this, ever. Even if you think you're innocent, even if you think you can handle it, never waive your right to counsel. Saying, I don't need a lawyer doesn't make you look confident, it makes you look naive. And prosecutors love defendants who talk too much without representation. Here's the truth. DUI law is one of the most technically complex areas of criminal defense. It combines criminal procedure, administrative law, and biochemical evidence. You're not fighting a human being, you're fighting data, machine data, officer notes, field procedures, and state calibration logs. Without a lawyer, you can't challenge that data. You can't request discovery, verify calibration certificates, or cross-examine the arresting officer on procedural lapses. You're fighting blind. So, instead of saying, I don't need a lawyer, you calmly say, I would like to speak to an attorney before answering any questions. That's a legal invocation. It stops questioning immediately under Miranda, and it signals that you understand your rights and you're exercising them with precision, not emotion. 10. I know I'm under the limit. This one might sound like confidence, but it's fatal. You're claiming scientific certainty about your blood alcohol level, something you can't possibly know without a calibrated device. That statement becomes a direct contradiction once the officer runs the test. And remember, the limit, 0.08 in most states, is not a shield. Even if you blow 0.06, the officer can still arrest you for driving while impaired if they observe diminished coordination, slurred speech, or erratic driving. The legal standard isn't just numerical, but it's behavioral. From a biological standpoint, your actual impairment begins long before 0.08. Studies by the National Highway Traffic Safety Administration, NHTSA, show that at 0.04 BAC, your visual tracking slows by 25%. At 0.05, your reaction time lengthens by nearly 40%. So when you say, "I'm under the limit," you're claiming precision that your body's physiology has already contradicted. The officer will write it in their report. Subjects stated they believed they were under the limit. That line becomes evidence of awareness and risk-taking, the foundation for proving negligence. So never, ever estimate your BAC allowed. The correct mindset is don't speculate, don't self-assess, don't volunteer data. 11. I can't afford to get arrested. This statement might come from fear, but to the officer in the court, it sounds like motive. You've just told them that you have a reason to lie, evade, or manipulate. Prosecutors can and do use that line to suggest you were trying to conceal your intoxication. Every word that reveals emotional desperation paints you as unreliable. Calmness, by contrast, reads as credibility. When you're pulled over, your sympathetic nervous system kicks in. Heart rate spikes, pupils dilate, palms sweat. Those are natural stress responses, but combined with your verbal anxiety, statements like "please don't arrest me" or "I can't afford this," they mimic signs of intoxication, tremors, erratic breathing, watery eyes. The officer's training manual actually teaches them to document emotional volatility as a secondary indicator of impairment. So your panic doesn't earn sympathy. It feeds the checklist that justifies your arrest. The better approach is quiet composure. Breathe slowly through your nose, avoid fidgeting, and keep your hands visible. Your calm body language becomes your silent defense. 12. I just brushed my teeth, or I just used mouthwash. People think this helps, that it proves cleanliness or sobriety, but chemically, it's one of the worst things you can say. Many mouthwashes contain up to 27% ethanol. That's over 50 proof alcohol. When you mention mouthwash, the officer is immediately trained to disregard a low BAC result as masking, or worse, to treat a high reading as residual mouth alcohol. Here's the science. When you rinse or gargle, alcohol residues linger in the mucosal membranes of your mouth and throat. A breathalyzer measures air from your lungs, but if that air passes through alcohol residue, your reading can spike dramatically for up to 10 to 15 minutes afterward. So if you mention mouthwash, you've just alerted the officer to potential interference, but not in your favor. They'll either wait longer to retest you, or they'll note possible alcohol odor and assume you're lying about drinking. The correct move is simple. Say nothing about mouthwash, gum, mints, or anything else. Don't offer explanations. Don't volunteer context. Let the science stand on its own. Your attorney can challenge the timing of the test later. Teen, why are you stopping me? You may feel you have a right to know, and you do, but this isn't the time to challenge it. When you ask why, it introduces tension. The officer interprets it as resistance. In their mind, the stop has already begun on reasonable suspicion. And here's the key. The officer's body camera is running. That footage doesn't just capture what's said, it captures tone, posture, and emotional temperature. A single defensive phrase can be reframed as uncooperative attitude in the report, giving the state stronger justification for extending the stop. So don't ask why. Wait for the officer to state their reason. They're legally required to. Your role is to listen, not debate. If you believe the stop was unlawful, that's something your lawyer will challenge later, not something you argue on the roadside. Now let's step back and talk about something rarely explained to the public: the science of rising BAC. This principle can make or break your case, and understanding it is crucial. Your BAC doesn't rise instantly after drinking. It takes time for the alcohol in your stomach to absorb into your bloodstream, typically 30 to 90 minutes. During that absorption phase, your breath alcohol can rise faster than your blood alcohol, so if you're stopped shortly after your last drink, your breathalyzer might read higher than your actual BAC at the time you were driving. That's called post-driving rising BAC. This is one of the strongest scientific defenses in DUI cases, but only if you don't sabotage it with your words. If you admit to just finishing a drink or having one right before leaving, you've destroyed that defense. You've anchored your timeline to the peak of your BAC curve. In other words, your honesty becomes the evidence that convicts you. So the rule is simple. Don't discuss when, where, or how much you drank. That's all time-sensitive data. And time is what determines guilt in these cases. 14. I'll fail it anyway. Never assume defeat before you've even been tested. That statement can be interpreted as an admission of guilt, even if your BAC turns out to be below the limit. Legally, prosecutors can argue that you believed yourself to be impaired. Intent matters in many jurisdictions. Psychologically, you've handed the officer confirmation bias. Interpret every small cue, from your balance to your breathing, through the lens of assumed guilt. And biologically, fatalism changes your physiology. When you resign yourself to failure, your breathing quickens, your mouth dries, and your tone weakens. All subtle signs of nervousness that mimic intoxication. So, no fatalistic language. Stay neutral. Your words should show composure, not surrender. 15. I'm not drunk. It sounds like the right thing to say, doesn't it? A firm denial. But this statement is a trap, linguistically and legally. Because when you say, I'm not drunk, you've already adopted the officer's framing. You've accepted that this is a conversation about your intoxication level, not about the legality of the stop or the validity of the test. You've entered their narrative, and from there, you can't win. If you fail the test, your denial becomes deception. If you pass, the statement looks irrelevant. There's no upside, only risk. Instead, remember the core principle. You are not required to answer questions that can incriminate you. Your best protection isn't argument, it's silence paired with respect. Now let's wrap this up with what I call the mission principle. You can't control the officer's interpretation, you can't control the machine's calibration, but you can control yourself. Your words, your breathing, your tone, your calm. That's your real defense. This isn't about evading justice. It's about ensuring that justice functions the way it's supposed to, through evidence, not intimidation. Because when that moment comes, when the lights flash, the siren wails, and your pulse spikes, your only real protection is the knowledge you carry into that silence. I'm not here to teach you how to beat the system. I'm here to teach you how to stay in control of yourself within it. Remember, calm is power, words are evidence, and silence used wisely is your strongest legal shield. Now that you know what never to say during a breathalyzer test, you're already 10 steps ahead of most people who get caught off guard. And if you want to go deeper, to learn how officers are trained to detect impairment and the hidden ways they can misuse that discretion, make sure you subscribe. Because this isn't just about traffic stops, it's about protecting your freedom, your record, and your peace of mind. You don't get a second chance to handle that moment right. But after today, you'll never need one. Thank you for watching this video. If you'd like to watch another fascinating video like this, click on one of the boxes on your screen right now.